At approximately 3:47 a.m. Eastern Standard Time this morning, federal agents from the Treasury Department's Financial Crimes Enforcement Network executed simultaneous asset seizure operations across 17 jurisdictions in what legal experts are calling the most aggressive financial enforcement action ever taken against a former president. The documents filed under seal in the Southern District of New York reveal something that should make every American who believes in equal justice under law pay very close attention, because what happened in those pre-dawn hours represents either the culmination of a years-long investigation into systematic financial crimes or the weaponization of federal power on a scale we've never witnessed. Either way, the implications for our republic are staggering, and before this video ends, you're going to understand exactly why the next 72 hours will determine whether our institutions still function or whether we've crossed a line from which there's no return. According to three sources familiar with the Treasury investigation, who spoke on condition of anonymity due to the sensitivity of ongoing proceedings, federal investigators have frozen approximately $4.2 billion in assets traced to offshore accounts linked to entities controlled by or benefiting Donald Trump. The seizure orders, executed in coordination with financial regulators in the Cayman Islands, Switzerland, Dubai, Singapore, and the British Virgin Islands, target shell corporations established between 2016 and 2024 that prosecutors allege were used to conceal income, evade tax obligations, and potentially launder funds from foreign sources. The timing of this enforcement action, coming just weeks after special counsel filings in the classified documents case and days before critical appellate deadlines in the January 6th proceedings, has ignited fierce debate about whether we're witnessing legitimate law enforcement or the final stages of what Trump's defenders have long called a political witch hunt designed to disqualify him from public life permanently. If you want to stay ahead of breaking developments in this story, as new court filings emerge and as the political fallout reshapes the 2026 landscape, make sure you're subscribed to this channel with notifications turned on, because mainstream media outlets are going to bury the details that matter most, and we're going to be covering every document, every legal maneuver, and every political consequence as this situation unfolds in real time. The credibility of these allegations rests on documentation that prosecutors have been assembling since 2019, when forensic accountants at the Treasury's Office of Foreign Assets Control first flagged suspicious transaction patterns involving real estate purchases in Dubai and Panama City. The initial red flags emerged from routine compliance reviews mandated under the Bank Secrecy Act, but according to multiple people briefed on the investigation's evolution, what began as standard financial monitoring transformed into a comprehensive criminal probe after investigators discovered what they describe as a sophisticated network of nominee directors, layered corporate structures, and transaction routing designed specifically to obscure beneficial ownership and the ultimate destination of funds. The evidence package presented to the federal magistrate judge who authorized the seizure warrants includes over 14,000 pages of banking records, wire transfer documentation, corporate registration filings from 7 countries, and testimony from cooperating witnesses including accountants, attorneys, and business associates who have provided detailed accounts of the mechanisms allegedly used to move money offshore, while simultaneously claiming financial hardship in domestic legal proceedings. To understand why this particular enforcement action carries such explosive potential, you need to understand what differentiates these allegations from the numerous other legal challenges Trump has faced over the past 8 years. Unlike the Manhattan District Attorney's prosecution involving alleged business record falsification or even the federal classified documents case, this Treasury action strikes at the fundamental question of whether Trump has systematically deceived the American people about his financial condition, while simultaneously hiding assets that should have been disclosed, should have been taxed, and potentially should have been seized years ago if they represent proceeds from illegal activity. The legal architecture supporting this seizure draws on statutes that carry some of the most severe penalties in federal criminal law, including provisions of the Bank Secrecy Act that authorize up to 10 years imprisonment per violation, the Foreign Corrupt Practices Act, which prohibits payments to foreign officials to obtain business advantages, and potentially even the Trading with the Enemy Act, if investigators establish that any of the frozen accounts received funds from sanctioned entities or individuals. The story of how federal investigators reached this point begins not in 2024 or even 2020, but in the summer of 2015, when Trump first announced his presidential campaign and began the financial disclosure process that would eventually create the documentary trail prosecutors are now using against him. On June 16, 2015, Trump filed his first financial disclosure form with the Federal Election Commission, a document required of all presidential candidates that asks for detailed information about income, assets, debts, and financial interests. That initial disclosure, which Trump famously described as showing he was worth over $10 billion, listed hundreds of income sources and assets, but according to forensic accountants who have compared those disclosures against banking records now in federal custody, at least 47 significant income streams and 18 major assets were omitted from the public filing. The pattern of omission becomes particularly significant when you examine which entities were excluded, because nearly all of them share common characteristics, including foreign incorporation, nominee directors who are not members of the Trump family or Trump Organization leadership, and transaction histories that suggest they were deliberately structured to remain below reporting thresholds that would trigger automatic scrutiny. Between 2016 and 2020, while Trump served as president and continued filing annual financial disclosure forms, investigators now allege that funds continued flowing into the offshore network even as Trump publicly claimed his business was suffering due to his political activity and even as he fought legal battles in New York civil court, claiming he lacked sufficient liquid assets to post bonds or satisfy judgments. This contradiction forms the core of the prosecution theory because if Trump controlled access to billions in offshore accounts while simultaneously claiming financial hardship in domestic proceedings, that pattern could constitute fraud on the court, a separate criminal offense that carries contempt sanctions and potential imprisonment regardless of the underlying financial crimes. The mathematical precision of how this alleged scheme operated reveals sophistication that prosecutors argue demonstrates consciousness of guilt. According to banking records obtained through mutual legal assistance treaties with foreign financial regulators, the offshore accounts received wire transfers that were carefully structured to fall just below the $10,000 reporting threshold that automatically triggers currency transaction reports. Over an 8-year period, investigators have identified more than 6,000 individual wire transfers, each ranging from $8,000 to $9,900, that collectively moved over $200 million from US-based entities into the offshore network. The painstaking nature of this structuring, with transfers executed on precise schedules and always remaining below the statutory threshold, is what financial crime prosecutors call smurfing, a technique typically associated with drug cartels and international money laundering operations, not with legitimate business enterprises owned by individuals who claim to be billionaires with nothing to hide. If you're beginning to understand why this case represents something categorically different from the other legal challenges Trump has navigated, hit that like button. Because what you're about to hear regarding the human intelligence sources who provided testimony to the grand jury is going to make the evidence even more damning and is going to reveal why Trump's legal team has been in emergency session since 4 a.m. this morning, trying to figure out whether they're dealing with a survivable legal threat or whether this is the case that finally breaks through every defense strategy they've employed for the past 8 years. The decision to move forward with asset seizure rather than simply filing criminal charges represents a calculated strategic choice by prosecutors, and understanding that choice reveals just how confident federal investigators are in their evidence. Under federal asset forfeiture law, the government can seize property that is either the proceeds of criminal activity or was used to facilitate criminal conduct, and critically, the burden of proof in civil forfeiture proceedings is lower than in criminal trials. By freezing the assets now, prosecutors accomplish several objectives simultaneously. They prevent the dissipation or transfer of funds that might represent evidence or potential restitution. They create enormous financial pressure on Trump to cooperate or negotiate. and they establish facts in a civil proceeding where Trump's Fifth Amendment privilege against self-incrimination could be used against him in ways that wouldn't be permissible in a criminal trial. The legal architecture is devastatingly effective because even if Trump is never criminally convicted, the government can still prevail in the forfeiture action using the preponderance of evidence standard, meaning they only have to prove it's more likely than not that the funds are connected to illegal activity. The human sources who provided testimony to the grand jury include individuals whose credibility prosecutors have spent years establishing. According to multiple people briefed on the grand jury proceedings, at least 4 cooperating witnesses have provided detailed testimony about their roles in establishing offshore entities, opening bank accounts using nominee directors, and executing wire transfers at Trump's direction or at the direction of Trump Organization executives acting on his behalf. These cooperators include a former accountant who worked for the Trump Organization for 12 years and who maintained detailed contemporaneous notes documenting instructions he received regarding offshore account management, a corporate formation specialist based in Panama who established 17 shell companies between 2016 and 2019, and who has provided prosecutors with emails and text messages showing communication with Trump Organization executives, an attorney who advised on the legal structures used to layer ownership, and who has testified about conversations in which he was told the purpose was to keep assets private and away from potential judgment creditors, and most damagingly, a family member of one of Trump's business partners who has provided testimony about conversations in which Trump allegedly discussed the offshore accounts and described them as protection against legal exposure and political enemies. The timeline of when key figures in this investigation began cooperating reveals a pattern of mounting pressure that ultimately broke the protective wall Trump's organization had built around these operations. The first cooperator approached federal investigators in March 2022, just weeks after New York Attorney General Letitia James filed her civil fraud lawsuit against Trump and the Trump Organization. According to sources familiar with the proffer sessions, this initial cooperator, believed to be the former accountant, contacted the FBI after concluding that he was likely to face professional license revocation and potential criminal charges if the New York investigation expanded. His cooperation led investigators to the Panama-based corporate formation specialist, who was approached in September 2022 and who initially denied any wrongdoing but eventually agreed to cooperate after being shown bank records that contradicted his initial statements. The attorney cooperator came forward in January 2023 after receiving a target letter from federal prosecutors, and the family member cooperator agreed to testify in June 2023 after being granted limited immunity from prosecution. The substance of what these cooperators have told investigators paints a picture of systematic deception that spans nearly a decade and that allegedly involved deliberate steps to conceal assets from regulators, tax authorities, and courts. The former accountant has testified that he was instructed to maintain 2 sets of books, one that tracked actual income and assets, and another that was used for external reporting purposes. He has described meetings in which he was told to exclude certain offshore accounts from financial disclosure forms and to structure those accounts in ways that would make them difficult for investigators to trace back to Trump. The corporate formation specialist has provided detailed testimony about how the offshore entities were established, with layers of nominee directors whose identities appeared in public corporate registries, while Trump or Trump Organization executives retained actual control through private agreements and powers of attorney that were never publicly filed. The attorney cooperator has testified about legal opinions he provided that described the offshore structures as high risk and potentially problematic if ever scrutinized by regulators, and he has recounted conversations in which he was told his concerns were noted, but that the business advantages of the offshore structures outweighed the legal risks. The family member cooperator has provided testimony about casual conversations in which Trump allegedly described the offshore accounts as untouchable by his enemies and as providing protection that his domestic holdings could never offer given the political targeting he faced. The question every Trump supporter needs to wrestle with right now is whether this cooperator testimony represents truth-telling by insiders who witnessed criminal conduct, or whether it represents the predictable result of federal prosecutors pressuring vulnerable individuals until they say what the government wants to hear. This is not a simple question, and the answer has profound implications not just for Trump's legal future, but for whether our justice system still operates with integrity or whether we've descended into a politicized prosecution model where the target is selected first and the evidence is then assembled to fit the predetermined outcome. Take a moment and leave your thoughts in the comments about whether you believe federal prosecutors are following evidence wherever it leads, or whether this entire investigation represents the culmination of an 8-year effort to destroy Trump by any means necessary. Because the comment section on this video is going to reveal whether Americans still share any common understanding of what justice looks like, or whether we've fractured so completely that we can't even agree on basic standards for evaluating evidence and prosecutorial conduct. The evidence specificity that makes this case particularly dangerous for Trump comes from the documentary record that corroborates cooperator testimony. Prosecutors have obtained banking records showing that on March 14, 2018, a wire transfer of $8,900 was sent from a Trump Organization account to a bank in the Cayman Islands, with memo line notation that matches a real estate transaction the former accountant testified about. They have corporate registry documents from the British Virgin Islands showing that a company called Meridian Ventures Limited was incorporated on June 3, 2016, just weeks before Trump accepted the Republican nomination, and showing that the company's director of record was a Panamanian attorney who has testified he never exercised any actual control over the entity and that all instructions came from Trump Organization executives. They have emails between Trump Organization attorneys and offshore banking compliance officers discussing documentation requirements for account opening, with one email from November 2017 specifically stating that the beneficial owner information being provided to the bank should be considered confidential and should not be shared with U.S. authorities without prior consent. They have tax returns filed with the IRS that do not report income from certain offshore entities that banking records show were distributing funds to Trump or Trump family members during the same tax years. And most devastatingly, they have contemporaneous notes from the former accountant that include entries like July 23, 2019, meeting with DJT regarding Cayman structures, confirmed he wants accounts kept separate from disclosure forms, believes political enemies trying to access financial records, and August 6, 2020, conference call with legal team regarding Dubai property transfer, decision made to use offshore entity to avoid US reporting requirements. The reaction from Trump's legal team and political allies has been swift and predictable, with immediate claims that this enforcement action represents the weaponization of government power and that the seizure was executed for maximum political damage at a time when Trump is positioning for another presidential campaign. Within hours of the seizure becoming public, Trump posted on his social media platform that he is the victim of yet another witch hunt by corrupt federal agents who are terrified of his political return and who will stop at nothing to prevent the American people from choosing their president. His attorneys have filed emergency motions seeking the unsealing of the probable cause affidavit that supported the seizure warrants, arguing that Trump has a right to confront his accusers and to examine the evidence against him before his assets remain frozen. Congressional Republicans have announced investigations into the Treasury Department's decision-making process, with some members suggesting that the seizure was politically motivated and timed to inflict maximum damage ahead of the 2026 midterm elections. Right-wing media figures have characterized the enforcement action as the final proof that we live in a banana republic where federal law enforcement has become an arm of the Democratic Party and where no conservative political figure is safe from persecution disguised as prosecution. If you believe the political stakes of this moment demand that more Americans understand exactly what's happening and what the evidence actually shows, rather than accepting partisan talking points from either side, make sure you're subscribed to this channel, because over the next 72 hours we're going to be obtaining and analyzing the actual court documents as they become public, We're going to be speaking with former federal prosecutors and defense attorneys to understand what the legal standards are and whether this enforcement action meets those standards. And we're going to be tracking the political fallout as this story dominates the news cycle and potentially reshapes the entire 2026 electoral landscape. The prosecutorial strategy behind executing this seizure now, rather than waiting until a criminal case was fully developed, reveals sophisticated thinking about leverage and timing. By freezing the assets before filing criminal charges, prosecutors accomplish several tactical advantages. First, they create immediate financial pressure on Trump that may make negotiation more attractive than protracted litigation. Second, they smoke out defensive strategies and legal theories that Trump's team might otherwise have held in reserve for a criminal trial. Third, they establish a public record of allegations that will influence grand jury deliberations if and when criminal charges are formally pursued. Fourth, they force Trump to make strategic choices under time pressure because federal forfeiture law requires that claimants contest the seizure within strict deadlines or risk permanent forfeiture by default. And fifth, they create the opportunity for Trump's legal team to make mistakes, either in public statements that could constitute admissions or in litigation filings that box them into positions they'll later regret when criminal charges follow. The forward timeline that should concern every American watching this situation unfold includes several critical deadlines and decision points. Within 35 days of the seizure, Trump must file a claim contesting the forfeiture and must post a bond in an amount sufficient to cover potential legal costs if the government prevails. Within 90 days, Trump must file an answer to the government's forfeiture complaint setting forth his defenses and explaining why the seized assets are not subject to forfeiture. During this same 90-day period, prosecutors will be deciding whether to file criminal charges, with the analysis depending heavily on how Trump responds to the forfeiture proceedings and whether his legal filings provide additional evidence that could be used in a criminal case. Within 6 months, absent settlement or dismissal, the forfeiture case will proceed to discovery, meaning Trump will be required to respond to interrogatories, produce documents, and potentially sit for depositions where his Fifth Amendment rights will not protect him from adverse inferences. And within 12 months, absent settlement, the case will likely proceed to trial, where a judge or jury will determine whether the government has proven by a preponderance of the evidence that the seized assets are connected to illegal activity. The scenario modeling that legal experts are engaging in today reveals just how consequential this enforcement action could be, depending on which pathway Trump chooses to follow. Scenario 1 is that Trump contests the forfeiture vigorously, files aggressive legal motions challenging the constitutionality of the seizure, claims selective prosecution and political motivation, and attempts to turn the proceeding into a referendum on government overreach. In this scenario, the proceedings become a media circus. Trump uses the case as proof that he is being persecuted, and the outcome depends entirely on whether the evidence is as strong as prosecutors believe. If the evidence holds up, Trump faces not only the loss of $4.2 billion in assets, but also potential criminal charges that follow from findings made in the civil forfeiture proceeding. If the evidence is weaker than prosecutors claim, Trump emerges as vindicated, and the case becomes another example of government overreach that actually strengthens his political position. Probability of this scenario, 45%. Scenario 2 is that Trump negotiates a settlement with prosecutors in which he agrees to forfeit some portion of the seized assets, pays substantial fines and penalties, and in exchange receives immunity from criminal prosecution related to the offshore accounts. This scenario requires Trump to accept some level of wrongdoing, which runs contrary to his entire public persona and strategy, but it provides certainty and allows him to avoid the risk of criminal conviction. In this scenario, Trump likely pays somewhere between $1 and $2 billion in combined asset forfeiture, fines, and back taxes, issues a statement saying he settled to avoid years of costly litigation, but maintains he did nothing wrong, and moves forward with his political activities without the cloud of pending criminal charges. Probability of this scenario, 30%. Scenario 3 is that the evidence is even more damaging than currently known, that additional cooperators come forward as the pressure intensifies, and that prosecutors file criminal charges within the next 60 to 90 days, alleging systematic financial fraud, tax evasion, and potentially even more serious offences if connections to foreign entities are established. In this scenario, Trump faces the prospect of a trial that could result in decades of imprisonment if convicted on multiple counts, and the political consequences include potential disqualification from holding federal office and the complete collapse of his remaining business empire. Probability of this scenario, 25%. The broader significance of this moment extends far beyond Trump's personal legal jeopardy and strikes at fundamental questions about institutional accountability and the rule of law in a deeply divided republic. If these allegations are proven true, they demonstrate that a person who served as president systematically concealed billions of dollars in assets, evaded tax obligations, and potentially defrauded courts and regulators over nearly a decade. The implications of that conduct going unpunished would be that we have created a two-tiered system of justice where the wealthy and powerful operate under different rules than ordinary Americans, where disclosure requirements are treated as optional by those with sufficient resources to hide assets offshore, and where even serving as president provides no immunity from accountability when the evidence of wrongdoing becomes overwhelming. Conversely, if these allegations ultimately prove to be overstated or if they represent aggressive interpretation of evidence by prosecutors who are motivated by political considerations, then we face an equally troubling reality in which federal law enforcement has been weaponized to target political opponents, in which prosecutorial discretion has become indistinguishable from persecution, and in which the awesome power of the federal government can be deployed to destroy anyone who challenges the prevailing political establishment. For those of you who want to continue following this story beyond YouTube and who want access to the actual court documents, legal analysis, and expert commentary as this situation develops, we're building a community on our website and on our email newsletter where we're providing deeper analysis than what's possible in these videos. You can find the link in the description below. We're also on Twitter where we're posting breaking updates as soon as court filings hit the docket and as new reporting emerges from sources close to the investigation. The political ramifications of this enforcement action will reverberate through the 2026 midterms and the 2028 presidential campaign, regardless of how the legal proceedings ultimately resolve. Trump's supporters will view this as the ultimate proof that he is being targeted by a corrupt establishment that fears his political return and that will use any tool available to prevent him from again assuming power. Trump's opponents will view this as long overdue accountability for conduct that would have landed any other American in prison years ago and as vindication of their belief that Trump has always been a grifter who enriched himself through decades of financial manipulation and illegal conduct. The question that should keep every American awake tonight is not whether you like or dislike Trump, not whether you voted for him or against him, but whether we still have institutions capable of fairly applying the law, regardless of political considerations, and regardless of how powerful the target we're going to find out over the next several months, which of these realities we're living in. And that answer will tell us whether the American experiment in constitutional government and equal justice under law is still functioning, or whether we've crossed into territory from which there may be no return. The Treasury Department has made its move. Trump's legal team is preparing its response. This is far from over, and in fact, what happened at 3:47 this morning may have been just the beginning of a legal and political earthquake that reshapes everything we thought we understood about power, accountability, and justice in 21st century America.